Good afternoon. Welcome to McGuireWoods SEC Compliance and Disclosure Update. I'm Dave Robertson, a partner in the firm's Securities and Capital Markets Department and moderator for today's program. McGuireWoods is a full-service law firm with more than 1,100 attorneys in 21 worldwide offices. More than 50 securities and capital markets partners and lawyers represent some of the nation's largest businesses and financial institutions. We regularly serve as counsel in public and private securities offerings and help clients understand and address unique business compliance issues and reporting requirements. Recently named Banking and Finance Law Firm of the Year by Law 360, McGuireWoods regularly ranks among the top leading law firms in capital market league tables. Before we begin today's program, I would like to call your attention to the Q&A icon in the lower left-hand corner of your screen. Please use this widget to submit questions you may have for our panelists at any time during the program. We will do our best to address your questions in the time allotted. However, if we're unable to do so, we will follow up with you by email. You will find a number of additional resources along the bottom of your screen, which we encourage you to explore during the presentation. Notably, the meeting materials folder includes a copy of today's presentation slides. Let me introduce our first speaker, Lisa Taylor. Based in our Jacksonville office, Lisa concentrates her practice on public company reporting and corporate governance matters. She will be discussing SEC changes related to shareholder proposals. Lisa?
Okay. Hey, Dave. On September 6th, the SEC's Division of Corporation Finance announced two significant procedural changes for responding to Exchange Act Rule 14a-8, no action request. You can access the announcement at the link on the slide. The SEC staff will continue to actively monitor correspondence and provide informal guidance to companies and proponents as appropriate. In cases where a company seeks to exclude a proposal, the staff will inform the shareholder proponent and the company of its position, including whether it concurs, disagrees, or declines to state a view with respect to the company's asserted basis for exclusion. Starting with the 2019 and 20 shareholder proposal season, however, the staff may respond orally instead of in writing to some no-action requests. The staff intends to issue a response letter where it believes doing so would provide value, such as more broadly applicable guidance about complying with Rule 14a-8. The staff continues to believe, as they noted in their Staff Legal Bulletin 14I and J, that when a company seeks to exclude a proposal under basis 5 or 7 of Rule 14a-8, an analysis by the board is often useful. We'll talk more about the board analysis a little later. If the staff declines to state a view on any particular request, the interested parties should not interpret that position as indicating that the proposal must be included. In those circumstances, the staff is not taking a position on the merits of the arguments made, and the company may have a valid legal basis to exclude the proposal under Rule 14a-8. And as always been the case, parties may seek a formal binding adjudication in the courts. So let's step back a little bit to the background of Rule 14a-8. Under Rule 14a-J, if a company intends to exclude a proposal from its proxy materials, it must notify the SEC not later than 80 calendar days before filing its definitive proxy statement and explain why the proposal may be excluded. So the practice has emerged that companies will submit a no-action request asking the staff to concur with its view that the proposal can be excluded under various exceptions to Rule 14a-8. For the past several decades, the SEC has responded to almost every request, and over the past few years, there's been hundreds of requests to respond to. So what does this mean, this announcement mean about what will happen in the future? switching. Well, in short, companies are not going to stop making their no-action requests. They'll still have to notify the SEC if they intend to exclude a proposal, and companies will generally decide to submit a no-action request with a full explanation to support their position consistent with past practice. After this September announcement, there's been some concern about when the SEC might provide oral guidance, or even more worrisome, when the SEC might decline to state a view. Fortunately, during some recent remarks to the Society for the Corporate Governance Eastern Regional Conference by the director of the SEC's Division of Corporation Finance, William Hinman, the SEC clarified that it would generally issue oral responses for more routine matters, such as the failure to provide a proof of ownership, and those responses would be documented on the SEC's site in real time. And it might decline to state a view when the staff believes it's not in the best position to make a decision about the proposal's excludability, and they're not sure exactly how frequently it would use that option. So what should companies do in the dreaded situation where the SEC declines to provide guidance? You know, the SEC noted in its announcement that if the company declines to express a view on a request, it doesn't mean that the proposal must be included. In that circumstances, the company must consider how strong does it feel its basis for exclusion is. Does it think that the shareholder might likely go to court to enforce the obligation to include a proposal? Do they think shareholders might have a negative reaction, or would the proxy advisors have a negative reaction? Could there be adverse publicity? Have they included similar proposals in prior years? How would shareholders likely vote? And how hard would it be to actually meet the requirements that the shareholder has proposed? After taking into consideration all those factors, the company has a couple of courses of action it can consider. You know, of course, it remains free to exclude the proposal. It may decide to negotiate a withdrawal from the shareholder proponent, in fact, might be more aggressive in that approach. It might decide that it's just simpler and less risky to include the proposal. On the other hand, it might decide to exclude it because it doesn't think that the shareholder would go to court. And then a company might decide to seek declaratory relief in court that it may exclude the proposal. It remains to be seen how frequently companies will find themselves in this situation, you know, for instance, how often the SEC will do that. And if there's, we'll have to see if any normal course of action tends to emerge when companies have this situation occur. One of the bases for exclusion of a proposal is the ordinary business exclusion. And this one has been a difficult one to use in the past few years. The staff's announcement of this change in handling shareholder proposals stated in the announcement that an analysis by the company's board is often useful when a company seeks to exclude a proposal under the 5th or the 7th exceptions. And to further emphasize this point, the SEC's just recently issued a new Staff Legal Bulletin 14K on shareholder proposals, and there's a link in the slide to access that if you want to read it. This presentation only addresses this new Staff Legal Bulletin 14K. Past McGuireWoods webinars have addressed prior staff bulletins on the ordinary business exclusion, including Staff Legal Bulletin 14I and J. So what are the matters addressed in this new Staff Legal Bulletin? They include the analytical framework of Rule 14A8I7, which is the ordinary business exclusion. The board analysis provided in a no-action request to demonstrate that the policy issue raised is significant to the company. The scope and application of the micromanagement basis for excluding a proposal, and proof of ownership letters. In the Staff Legal Bulletin, the staff identified two central considerations for the ordinary business exclusion. One, the proposal's significance, and two, the degree to which the proposal micromanages the company. So how do you evaluate the significance of a proposal to the company under an ordinary business exclusion? I think that's really... A significant policy exception depends in part on the connection between the significant policy issue in the proposal and the company's business operations. So the staff takes a company-specific approach to this. What might be a significant issue for one company is not necessarily a significant issue for another company. And the staff continues to emphasize that the request, the no-action request, should include a robust analysis substantiating the board's determination that the policy issue raised by the proposal is not significant to the company. The staff legal bulletin includes additional information about what the board analysis should include. And that includes a well-developed discussion of the board's analysis of whether a particular policy issue raised in a proposal is sufficiently significant in relation to the company. The no-action request should describe in sufficient detail the specific substantive factors that the board considered in arriving at its conclusion, as well as a non-exclusive list of these factors. The staff legal bulletin says that while the staff doesn't expect the board or a board committee to prepare the significant analysis that's included in the no-action request, they do want to see that an appropriate body with fiduciary duties to shareholders has given due consideration as to whether the policy issue presented is of significance to the company. The analysis should also include a delta analysis, and that means an explanation of the difference, or delta, between the proposal's specific request and the action already taken by the company. The board's analysis should explain whether the difference between the company's actions on the issue in the proposal and the proposals represents a significant policy issue to the company. Have the company's prior actions actually diminished the significance of the policy so that they can exclude it? That's really the question. The analysis should also include a prior voting analysis. So it should say whether the company's shareholders have previously voted on the matter and the board's views on the voting results. This includes a robust discussion explaining how the company's subsequent actions, intervening events, or other objective evidence of shareholder engagement on the issue bear to the significance of the underlying issue to the company. So, for instance, if the company has engaged with shareholders on the issues addressed in the proposal and have taken action on the proposal, then they could have diminished the significance of that proposal. We noted previously that there were two central considerations to the ordinary business exception. We just reviewed the first consideration, and that's significance. The second consideration is the extent of the micromanagement in the proposal. And that's an evaluation of the manner in which the proposal seeks to address the subject matter rather than the subject matter itself. In the staff legal bulletin, there's some examples of proposals on a similar issue, one of which is too prescriptive and one of which is not. So the question is really, how prescriptive is that proposal? Does it seek to impose a specific strategy, method, action, or outcome or timeline on the company? The analysis of whether a proposal is too restrictive looks at all aspects of the proposal, the whereas clauses as well as the resolution itself. And the staff legal bulletin expects the no action request to include an analysis of how the proposal would unduly limit management and the board's ability to manage complex matters with a level of flexibility to fulfill their fiduciary duties to shareholders. The staff legal bulletin also includes information about how the shareholders should prove their ownership of the company as required. And in fact, the staff legal bulletin includes a specific formulation. The bulletin also cautions companies not to apply an overly technical reading of proof of ownership letters and not to seek to exclude a proposal based on drafting variants if the proof of ownership letter has information that's clearly and sufficiently shows that the shareholder meets the minimum ownership requirements. So let's go back to consider what companies might do to address the change in the SEC's approach to shareholder proposals, where it might provide oral advice or decline to state a view. Perhaps one practical step to take is to have someone designated to field the calls from the SEC staff. That person should be generally familiar with no action process and the specific requested issue. They should have guidelines for conducting the call and asking appropriate questions. The company should create a record of its written and oral communications with the staff. And if the staff doesn't concur with the company's position, on that call, it's unlikely that they'll be able to make requests, but they could make subsequent written requests for reconsideration. Let's kind of review what might likely happen as a result of this change in the SEC's approach. Well, it certainly could provide more uncertainty because you won't for sure get a written answer. It may be good in that you might get a more quick response for a routine request or a request where the grounds for exclusion are clear, but it could embolden shareholder proponents and result in even more no action requests because the guidance is less clear. We might find that courts are less deferential to oral SEC guidance, and there could be more litigation both from shareholders who file suit to require inclusion of proposals or companies who want to seek declaratory relief. Just overall, larger investors might not sue companies because of the time and money it involves to do that, but they could use other methods to pressure companies such as just vote no campaigns or more joint activities with other shareholders. I hope this has given you some sense of the SEC's new approach to shareholder proposals and Staff Legal Bulletin 14K, which continues to emphasize how to provide a board analysis to use the ordinary business exceptions. Thanks. Turn it back to you.
Thank you, Lisa. Our next presenter is Karen Adams. Karen is counsel in the Securities and Capital Market Group and located in our Charlotte office. Karen's experience includes representing public and private companies in securities transactions and other general corporate matters. She'll discuss the SEC's new Rule 163B under the Securities Act. Karen?
Thank you. As mentioned, I will be discussing a new rule adopted by the SEC which permits all issuers to use test-the-water communications before filing a registration statement. The new rule, which is Rule 163B under the Securities Act, was originally proposed in February 2019 and was adopted on September 26th. It enables all issuers, regardless of size or reporting status, to test the waters with certain institutional investors before publicly filing a registration statement to gauge market interest in potential registered securities offerings. Currently, this is only available to issuers that qualify as emerging growth companies, and the new rule will be effective 60 days after publication in the Federal Register. As background, Section 5 of the Securities Act restricts any written or oral offers prior to the filing of a registration statement, and once an issuer has filed a registration statement, written offers are limited to a Section 10 statutory prospectus, and violations of these provisions are often referred to as gun jumping. And in 2012, Congress passed the Jobs Act, which added an exemption to the gun jumping provisions of Section 5 for a new category of issuers known as emerging growth companies. And these companies generally have annual revenues under roughly about $1 billion, but they can lose their status once they have been public for a year and have a market cap of at least $700 million, or once they have been public for 5 years. As part of the Jobs Act, a new Section 5D was added to the Securities Act, which permits emerging growth companies or persons authorized to act on their behalf to engage in oral or written communications with potential investors that are or are reasonably believed to be qualified institutional buyers or institutional accredited investors, either before or after the filing of a registration statement in order to gauge market interest in a contemplated securities offering. Since the adoption of the Jobs Act, These testing the water communications have been used in a significant portion of IPOs, and various groups have called for this option to be expanded to all issuers, and the SEC has now done that with the adoption of this Rule 163B. Some of the reasons cited by the SEC for the new rule include that it will level the playing field among issuers. It also provides flexibility and cost-effective means to evaluate market interest. And also, it reflects the SEC's continued efforts to encourage more registered securities offerings in the U.S., thus expanding access to public capital markets. And as the SEC's chairman stated, this benefits all investors, ultimately providing both Main Street and institutional investors with more opportunities to invest in public companies that, in turn, provide ongoing disclosures to their investors. I will now discuss some of the key provisions of the new rule. First, the rule is available to all issuers, not just emerging growth companies. So that includes WICSEs, non-WICSEs, reporting and non-reporting companies, investment companies, et cetera. And it is also available to persons authorized to act on behalf of the issuer, and most notably that includes underwriters. The permitted recipients of the communications are limited to investors that are financially sophisticated. So they must either be a QUIB as defined in Rule 144A, or an institution that is an accredited investor as defined in Reg D. The investors must actually meet the standards as QUIBs or institutional accredited investors, or the issuer must reasonably believe that they do so. The SEC did not specify the steps that an issuer must take to establish this reasonable belief. Instead, companies may continue to rely on methods they currently use to verify investor status in other contexts. Rule 163B communications are not required to be filed with the SEC, and they do not need to include any specific legends or disclaimers. However, even though they are not required to be filed, the SEC may request copies of the communications as part of their registration statement review process. And this is consistent with current practice for emerging growth companies. These testing the water communications are not free-writing prospectuses, and the SEC is amending Rule 405 to exclude both the Rule 163B and the Section 5D communications from the definition of a free-writing prospectus. And Rule 163B is not an exclusive rule. Companies may rely concurrently on other Securities Act communication rules or exemptions. Although exempt from the gun-jumping provisions of Section 5, testing the water communications under Rule 163B are considered offers under the Securities Act, and as such, they are subject to Section 12 liability, as well as the anti-fraud provisions of federal securities law. The SEC noted that information contained in the Rule 163B communications must not conflict with material information contained in the related registration statement. And in response to commenters' concerns that this could be challenging, especially if the offering strategy or messaging changed in response to investor feedback, the SEC clarified that this is not a condition to the rule, but is intended to remind issuers of their obligations under securities laws and the importance of not having material misstatements or omissions in the Rule 163B communications at the time they are made. The SEC recognized disclosures may change, but even where an issuer changes its offering terms or messaging, the material terms about the issuer itself, such as its financial condition and business operations, typically remain consistent. Some other considerations to be aware of. Regulation FD applies to these testing the water communications. So if a company is subject to Reg FD, which would include all public companies, then it should consider whether any information contained in the testing the water communications constitutes material non-public information that would trigger an obligation under Reg FD to publicly disclose the information, or whether an exception applies, such as obtaining confidentiality agreements. Also, in the adopting release, the SEC confirmed that the new Rule 163B does not modify the rules on general solicitations in connection with private placements, and that its 2007 framework for analyzing how an issuer can conduct simultaneous registered and private offerings still applies. So if an issuer engages in Rule 163B communications in close proximity to a private placement, it should consider whether the communications were conducted in such a way as to constitute a general solicitation that might disqualify the issuer from completing a subsequent private offering. And the SEC also eliminated a provision from the proposed rule that would have made Rule 163B unavailable for any communication that was part of a plan or scheme to evade the registration requirements of the Securities Act. The SEC was persuaded that this anti-evasion language might cause confusion or uncertainty and would risk limiting the utility of the rule. A few takeaways. While this new rule expands the ability for larger issuers to communicate with institutional investors, companies should exercise caution to make sure that all securities law requirements are complied with, including Reg FD if applicable. And also remember that these communications are subject to liability, securities law liability, and anti-fraud provisions, and thus should not contain any material misstatements or omissions. And then finally, on the last slide, I've included the actual text of the rule for your reference. And that's all I have.
Thank you, Karen. Presenting next is Adair Pantner. Adair is a Securities and Capital Markets Associate who's located in our New York office. He focuses his practice on corporate and securities law, representing public and private clients in a wide variety of transactions. He will be providing considerations for non-disclosure agreements and M&A deals. Adair?
Thanks, Dave. Good afternoon, all, and thank you for joining us. Granted, we don't have enough time to go through every provision you may encounter in an NDA, so I focused on a few interesting and often contentious provisions, and I'll attempt to give you a brief overview of the considerations for each. First is standstill agreements and Martin Marietta. So confidentiality agreements involving public companies typically include standstill provisions, which prohibit the recipient from using the confidential information provided for any purpose other than as set forth in the agreement, including to launch a hostile takeover of the disclosing party. This is, of course, in addition to the provision acknowledging that securities laws prohibit insider trading. The May 2012 decision of the Delaware Court of Chancery in Martin Marietta v. Vulcan Materials focused on how parties define transaction for the purposes of determining the scope of the recipient's use of the valuation material. In deciding whether Martin Marietta could use a valuation material in its pursuit of a hostile takeover, the court held that the definition of transaction was narrowly drafted and limited only to consensual transaction. As a result, Martin Marietta was found to have breached the confidentiality agreement and enjoined from moving forward with its hostile takeover efforts for 4 months. This demonstrates how certain provisions, including even the definition of transaction, can be used to restrict a recipient from initiating a hostile bid. It is therefore important for parties to make their intentions clear on these points. Consider including the words negotiated and the phrase between the recipient and the company so that it's clear that the evaluation material being exchanged can only be used in connection with a consensual transaction. Use of evaluation material and confidentiality. Negotiations over the definition of representative are important. The disclosing party will want this definition to be as broad as possible. For example, to include subsidiaries and financing sources. Conversely, the recipient will want to limit this definition. But even once representatives is defined, their obligations can become a sticking point in the negotiation. The recipient may try to eliminate any requirement making it responsible for the breaches of third-party representatives and replace any obligation to require the representatives to be bound with an obligation to direct or inform them of the confidentiality agreement. The argument most typically used by recipients is that they do not have control over their representatives. The disclosing party should try to include language like, recipient shall inform such representative of the provisions of this agreement and instruct it to comply with the provisions hereof. To fully protect itself from any liability for its representative's breaches, the recipient can request that its representatives enter into their own confidentiality agreement with the disclosing party. If the representative is reluctant to do this, an intermediate approach is to request that the representative sign a confidentiality agreement in favor of the recipient that mirrors the relevant provisions in the underlying confidentiality agreement. Return or destruction of evaluation material. The recipient is likely to object to the requirement to notify the disclosing party of its decision not to proceed with the transaction. The recipient's concern with including this provision is that the precise timing of a decision not to proceed with the transaction may not be clear, thereby potentially subjecting the recipient to liability if the recipient ultimately decides not to proceed with the transaction. Without this provision, however, the disclosing party will not know when to request the return of confidential information other than once a deal gets signed up. Ideally, the recipient should be obligated to return all evaluation material upon request. However, recipients often ask for the option of destroying materials instead of returning them. To the extent destruction is permitted, it is important for the disclosing party to have confirmation that the evaluation material was in fact destroyed. So the requirement to certify any destruction is usually not disputed by the recipient. However, some recipients take issue with the word certify, so you may decide to substitute the word certify with the language confirm in writing. Carve-out 1. Consider derivative materials. The ability to destroy evaluation materials is especially important in the case of derivative materials generated from the confidential information. For example, financial models, analysis, and reports, as these materials may contain proprietary information. The negotiation here will likely be between information reflecting and derived from the evaluation material versus containing the evaluation material. Carve-out 2, legal compliance. The recipient may also ask for the right to retain evaluation material for legal compliance purposes, so that it could bring or defend litigation related to the transaction, or respond to requests from regulatory authorities. When drafting this provision, note the important distinction between allowing the use of material as a sword versus using it as a shield. Carve-out 3, standard electronic backup files. The recipient may also request an exception for standard electronic backup procedures. Because due diligence data is often transmitted electronically, these materials are often embedded in electronic files as part of the company's normal backup procedures. For example, if a computer network is systematically backed up. Often, the disclosing party allows this carve-out, as long as access is limited to IT and legal personnel. Non-solicitation, non-competition. The disclosing party should consider the impact that a failed deal could have on its employees, such as the recipient poaching key employees. Most NDAs with competitors include non-solicitation provisions. However, the recipient will likely object, at least in part, to this language. Carve-out 1. Parties often compromise by limiting this particular provision to key employees. Carve-out 2, suppliers and customers. If the disclosing party wants to take a more aggressive position, it can restrict the recipient from soliciting or contacting any of its potential or actual suppliers or customers identified in the evaluation material, which may in essence function as a non-compete clause. A disclosing party might include this if the recipient is a competitor and has particular concerns about the recipient offering more favorable commercial terms to its suppliers or customers. The disclosing party should expect the recipient to resist this point, and the outcome will likely depend on the relative bargaining strength of each party. The enforceability of restrictive covenants, like non-solicitation and non-compete clauses, is dependent on state law. Please consult with counsel knowledgeable with the laws regarding antitrust considerations and the enforceability of restrictive covenants under applicable state law before drafting this provision. Buyer considerations. If the recipient agrees to a non-solicitation provision, consider the following. Term. The term of this provision may be shorter than the term of the agreement. We've found that 1 year is common. 2, who does it restrict? If the recipient's representatives are receiving evaluation material, the recipient may want to carve them out of this provision. The recipient may also want to restrict the application of this provision to only those employees the recipient first met as a result of the proposed transaction. 3, what does it restrict? The recipient may also want to limit the provision to only prohibit solicitations by deleting any reference to the word hire, so that hiring is permissible if the employee contacts the recipient on its own accord or responds to a general advertisement not targeting that person. If the provision also prohibits solicitation of customers and the recipient is in the same business as the disclosing party, consider inserting an exception for customers and suppliers that the recipient has existing relationships with or deals with in the ordinary course. Some final considerations. Mutual NDAs save time. More balanced terms are more favorable to the recipient and may mean a faster review and signing process. Most M&A transactions for cash involve unilateral NDAs, since only the seller discloses confidential information. However, there are typically matters both parties want to keep confidential, such as the fact that negotiations are taking place or the amount of the buyer's bid. So consider drafting a balanced NDA from the start to save time. 2, public company disclosure. As discussed earlier, if the disclosing party is a public company, consider including a standstill agreement restricting the recipient from making an unsolicited or hostile bid. Note, standstills typically limit the recipient's ability to buy and sell stock, so be prepared for pushback on the recipient's use of information in its regular activities. Market term for a standstill provision seems to be 1 year. You should, of course, have the recipient represent that they will comply with securities law wherever the company is listed. Reg FD generally prohibits public companies from disclosing material non-public information to certain people unless the information is publicly disclosed or the recipient agrees to maintain the information in confidence. Ensure that the NDA qualifies for the confidentiality exception to Reg FD. Limitations and risks. If information is wrongfully disclosed and becomes part of the public domain, it cannot become undisclosed and it loses its confidential nature. As we discussed, you may attempt to limit a recipient's use of confidential information by requiring them to destroy all information that derivatively uses confidential information. For example, if the recipient used the confidential data to create its own financial projections. Unfortunately, a recipient cannot unsee information. So disclosing parties should be cognizant of the risks involved with disclosure. Even with an honest recipient, the information you disclose may make its way into their commercial plan, regardless of the terms of the NDA, because it will remain in their residual memories, even unaided and without reference to written material. That is, they cannot unsee or segment the information that they have already seen. We hope this information was helpful. Please feel free to contact me directly with questions or comments.
Thank you, dear. Finally, we have Porter Durham. Porter is also a securities and capital markets associate who is located in our Charlotte office. He focuses his practice on M&A, securities, and other corporate matters. He will be discussing Rule 10b-5 after Lorenzo and Maloff. Porter?
Thank you, Dave. As he just said, today I'm going to be discussing Rule 10b-5 and the implications of the Supreme Court's decisions in Lorenzo versus the SEC and the 10th Circuit Court of Appeals decision in Maloof versus the SEC on 10b-5 fraudulent misstatement liability. So we'll start by giving a little bit of background on Rule 10b-5 and the Court's previous decision in Janus for context. Then we'll discuss each of Lorenzo and Maloof in turn, and finally we'll talk about the implications of those decisions going forward. It likely goes without saying that Rule 10b-5 is the most widely used and probably the most important anti-fraud rule included among the rules promulgated by the SEC under the Securities and Exchange Act of 1934. Rule 10b-5 acts as a catch-all provision. Its broad prohibitions make it unlawful for any person to employ any device, scheme, or artifice to defraud, to make any untrue statement of a material fact, or to omit to state a material fact necessary in order to make the statements made, in light of the circumstances under which they were made, not misleading, or to engage in any practice or course of business which operates or would operate as a fraud or deceit upon any person in connection with the purchase or sale of any security. Among the notable cases where the Supreme Court has examined the scope of Rule 10b-5 is Janus Capital Group versus First Derivative Traders. In Janus, the court considered whether Janus Capital Group and its wholly owned subsidiary, Janus Capital Management, could be held liable under Rule 10b-5b for false statements made in a mutual fund prospectus filed by Janus Investment Fund. For reference, Janus Investment Fund was an investor-owned mutual fund, though it was originally founded by Janus Capital Group, and Janus Capital Management served as its investment advisor. The court concluded that neither Janus Capital Group nor Janus Capital Management could be held liable because neither was the maker, quote unquote, of the false statements. The court noted that for purposes of Rule 10b-5, the maker of a statement is the person or entity with ultimate authority over the statement, including its content and whether and how to communicate it. Without control, a person or entity can merely suggest what to say, not make a statement in its own right. Notably, the court also pointed out that one who prepares or publishes a statement on behalf of another is not its maker. So in that context, earlier this year, the court followed up on its decision in Janus with its decision in Lorenzo versus the Securities and Exchange Commission. In Lorenzo, the court considered whether liability under Rule 10b-5 extended to those who did not make a false statement, as Janus defined make, but rather who disseminated false or misleading statements to potential investors with the intent to defraud. The petitioner in that case, Francis Lorenzo, was an investment banker with a registered broker-dealer in New York called Charles Vista. In the summer of 2009, Lorenzo's firm was hired by Waste to Energy Holdings to sell $15 million worth of debentures. Waste to Energy had previously reported assets totaling over $14 million, which they contended included intellectual property that the company valued at more than $10 million, although Lorenzo testified that he felt as though the company had overvalued, particularly overvalued that IP, which he contended didn't really work. Subsequently, in early October of that year, Waste to Energy disclosed that its IP was worthless, that it had written off all of its intangible assets, or all of its tangible assets, and that the company valued its current assets at less than $400,000. Then, on October 14th, Lorenzo sent 2 emails to prospective investors describing the debenture offering and stating that the investment had, quote-unquote, 3 layers of protection, including $10 million in confirmed assets. Lorenzo testified that these emails were sent at the direction of his boss and that his boss had supplied the content and approved the form of the messages. In 2013, the SEC instituted proceedings against Lorenzo, his firm, and his boss, and ultimately concluded that Lorenzo's conduct in sending the misleading emails violated Rules 10b-5 along with Section 10b of the Exchange Act and 17a1 of the Securities Act. So Lorenzo argued that because his boss had asked him to send the emails, supplied the central content for the emails, and approved the messages for distribution, he being Lorenzo, did not have ultimate authority over the communications and thus was not the maker of the fraudulent misstatements based on the court's holding in Janus. Therefore, he argued, he could not be found liable under Rule 10b-5b. The Commission agreed with his argument, but found that Lorenzo had violated subsections A and C of 10b-5, which, again, prohibit using any device, scheme, or artifice to defraud, and engaging in any act, practice, or course of business which operates as a fraud or deceit upon any person in connection with the purchase or sale of a security. In addition to finding that he violated Section 10b of the Exchange Act and 17a1 of the Securities Act. In its 6-2 decision, the court upheld the Commission's finding, holding that the words in these provisions are sufficiently broad to include within their scope the dissemination of false or misleading information with the intent to defraud. The court also noted that dissemination of false or misleading material is easily an artful stratagem or a plan devised to defraud an investor under subsection A, and that words act and practice in subsection C are similarly expansive and thus viewed them as sufficient to include disseminating false statements. Notably, the court added that the provisions are intended to capture a wide range of conduct. Applying them may present some difficult problems of scope in borderline cases. Purpose, precedent, and circumstance could lead to narrowing their reach in other contexts. And noted that one can readily imagine other actors for whom liability would typically be inappropriate. The court noted, however, that in this particular case, they felt that the case for liability against Lorenzo was pretty cut and dry. Justice Thomas authored a dissent against the court's opinion. In his dissent, Justice Thomas argued that the majority's interpretation was overly broad and that by holding Lorenzo primarily liable for misstatements that he had not made, as defined in Janus, it, quote, eviscerated the distinction between primary and secondary liability for fraudulent misstatements that was established in Janus. Thomas argued that the majority opinion creates overlap between the subsections of Rule 10b-5 that is not intended. He suggested that in light of the specificity of Rule 10b-5b, which expressly prohibits fraudulent misstatements, the scope of subsections A and C should not be construed to include primary liability for making or disseminating false statements, or else subsection B is functionally rendered entirely superfluous, in his words. In addition, Thomas contended that the majority opinion rendered Janus a quote-unquote dead letter. He reasoned that by finding Lorenzo, who is not the maker of the fraudulent misstatement, primarily liable for it, the court had diminished the maker standard for fraudulent misstatement liability. The dissent added that by failing to maintain the clear line between primary liability and secondary liability, such as for aiding and abetting, the majority opinion makes virtually any person who assists with the making of a fraudulent misstatement primarily liable, and thereby subject not only to SEC enforcement, but also to private lawsuits. In August of 2019, the first case by U.S. Court of Appeals to apply the court's holding in Lorenzo was decided by the 10th Circuit Court of Appeals in the case of Maloof versus the Securities Exchange Commission. Dennis Maloof was an executive at two financial firms, a brokerage firm, which was a branch of Raymond James, and an investment advisor called UASNM. In 2007, after Raymond James became concerned about the conflict of interest between these two roles, Maloof said the branch sold the branch of Raymond James for just over $1 million. Under the terms of the sale, Maloof received the purchase price in installments based on the Raymond James branch's collection of brokerage fees going forward. After the sale, Maloof began steering his UASNM clients to the Raymond James branch without seeking competing bids, which was required under UASNM's best practices procedures. Maloof also failed to disclose the installment payment arrangement that he had with the purchaser of the Raymond James branch to either UASNM or his clients. Subsequently, UASNM failed to disclose that conflict of interest on its Forms ADV filed with the SEC, and instead actually disclosed that there were no conflicts of interest for any of its employees and that none of them received commissions or fees from Raymond James. In response to the SEC's claims that he had violated Rules 10b-5A and C, Maloof echoed the dissent in Lorenzo and argued that the failure to correct the misstatement was inseparable from the misstatement itself. He argued that finding liability under Rules 10b-5A and C based on the failure to correct the misstatement, quote-unquote, obliterates the distinction between liability for fraudulent misstatements and the other categories of conduct that are prohibited under Rule 10b-5. Applying the decision in Lorenzo, The Tenth Circuit found that Malouf's conduct, specifically his failure to disclose his conflict of interest despite his knowledge of the conflict and his knowledge of UAS&M's misstatements in its forms ADV, ran afoul of Rules 10b-5 A and C. It's also worth noting, as an aside, that the Tenth Circuit affirmed the SEC's finding that Malouf had violated the Investment Advisors Act by aiding and abetting UAS&M's violation of the Investment Advisors Act, which suggests that primary liability under Rule 10b-5 does not necessarily preclude a finding of secondary liability, particularly under a separate statute. So Lorenzo and Malouf are notable for a number of reasons. First, they mark a notable expansion of fraudulent misstatement liability beyond the maker standard established in Janus. As the Lorenzo decision makes clear, the application of Rules 10b-5 A and C as contemplated by the court can capture a wide range of conduct. In Lorenzo, we see liability extended to a knowing disseminator of false information, and in Malouf, we see liability extended to a knowing failure to correct a material misstatement, but in neither case was the offending party the, quote, maker of the misstatement as defined in Janus. This stands in contrast to the standard set in Janus, which limited fraudulent misstatement liability exclusively to the maker of a fraudulent misstatement. Notably, the court does not suggest what sort of limitations should apply to this new and more expansive reading of Rule 10b-5. As mentioned before, the court does note that one can readily imagine other actors tangentially involved in the dissemination of fraudulent information for whom liability would typically be inappropriate. The court suggests, for instance, that a mailroom clerk would likely not fall within the standards for liability. But it leaves open-ended what sort of circumstances could lead to a narrowing of the application of the rules. Second, as noted by the dissent in Lorenzo, these decisions also expand primary liability, or at the very least blur the lines between primary and secondary liability for fraudulent misstatements. This is particularly noteworthy because under the court's previous decisions in Janus and Central Bank of Denver versus First Interstate Bank of Denver, a private right of action cannot be premised on secondary liability, such as aiding and abetting. By expanding primary liability to knowing and reckless disseminators of false information, and those who knowingly fail to correct misstatements, Lorenzo and Malouf open up a new category of conduct to private action. Previously, those who knowingly or recklessly provided substantial assistance to another person in violation of Rule 10b-5, such as disseminators of fraudulent misstatements of others, could only face claims of aiding and abetting brought by the SEC. After Lorenzo, there is some question about what sort of conduct constitutes intentional dissemination of fraudulent information and therefore is subject to primary liability under Rule 10b-5 and potentially to private action as well, and what sort of conduct simply qualifies as knowingly providing substantial assistance to the maker of a fraudulent misstatement and therefore is only subject to secondary liability and to claims brought by the Commission. Finally, Lorenzo decision provides a counter to the maker standard established in Janus. As noted in the dissent, the decision in Lorenzo and subsequently the decision in Malouf calls into question the viability of the maker standard set by Janus. In response to this critique by the dissent, the majority opinion in Lorenzo notes that the maker standard will still preclude liability where a defendant neither makes nor disseminates false information issued by a different entity that controls the statement's content. For instance, where a defendant merely helps draft misstatements but has no control over the content. Viewed together, Janus and Lorenzo seemingly serve as guardrails, providing for liability for the maker of a fraudulent misstatement on the one hand, and the knowing disseminator of fraudulent misinformation on the other hand, and they open up a debate over what amount of control over a fraudulent misstatement is enough, and what level of involvement and distribution is required for liability under Rule 10b-5. In Malouf, the Tenth Circuit took the first step towards aggressing that middle ground because it was decided in the context of an SEC enforcement action. It remains to be seen whether it will have broader implications on private actions, but Malouf shows that the court's new and broader standard for Rule 10b-5 misstatement liability may be interpreted to apply liability to a party that is neither the maker nor the disseminator of fraudulent misinformation, and thus that the court's new, and suggests that the court's new standard does in fact, or can in fact, capture a wide range of conduct. As one additional note, we've had some questions from clients over whether under this new standard, fraudulent misstatement liability might arise where a member of a deal team is uploading documentation to a virtual data room. It's worth noting that neither Lorenzo nor Maloof disposed of the scienter requirement for Rule 10b-5 misstatement liability. In both cases, the petitioners were found to have acted knowingly. So where information is added to the data room, it seems unlikely that liability under Lorenzo or Maloof would arise unless the person uploading that information knew or was recklessly unaware that the information was false and failed to speak up. Thank you very much.
Thank you, Porter, and thanks to the entire panel for such great presentations. In closing, as a reminder, if we did not address your questions during the call, we will follow up with you shortly by email. Feel free to contact us with any additional questions or comments in the interim using the information displayed on your screen. On behalf of McGuireWoods, thank you all for joining us today.